The call came in at 11:47 p.m. on a Tuesday in February 2018. A resident of the Glenwood Park neighborhood in southeast Atlanta had reported a fire at a vacant commercial property on Flat Shoals Avenue. By the time the first engine company from Atlanta Fire Rescue Station 19 arrived, the single-story structure, a former dry cleaning business that had been empty for approximately 14 months, was burning with the kind of sustained, even intensity that experienced firefighters learn to read before they have consciously begun to analyze. The watch commander on scene noted in his incident report that the fire's behavior was consistent with an accelerant-assisted origin. He noted it as a preliminary observation, not a conclusion. The distinction would matter less than it should have. The structure was a total loss by 2 a.m. No one had been inside. No injuries were reported. By the standard triage of emergency response, the incident was a property fire with no casualties, serious, worth investigating, but not the kind of event that commands extended institutional attention in a city that averages more than 300 structure fires per year. What elevated it was a pattern. The Flat Shoals fire was the fourth fire in the Glenwood Park and East Side neighborhoods in 11 weeks. The three preceding fires had also occurred at vacant or underutilized commercial properties, also at night, also with preliminary fire behavior suggesting accelerant use. The Atlanta Fire Investigation Unit had been working the series for 6 weeks. They had a theory. They needed a case. The investigation moved quickly after the fourth fire, and the speed with which it moved was, at the time, understood entirely as a measure of competence. The Fire Investigation Unit assigned 2 senior investigators to the series. Both had extensive experience. One had been with the unit for 11 years, the other for 8. They had worked fires together before and had developed the kind of professional shorthand that long collaboration produces. They approached the Flat Shoals scene the morning after the fire with a clear investigative framework. 4 fires, similar targets, similar timing, similar burn characteristics. The hypothesis of a serial arsonist was not a leap. It was, under the circumstances, the logical inference from available data, and the investigators pursued it with the methodical confidence that their experience warranted. The scene examination at Flat Shoals took 2 days. The investigators documented the burn patterns, collected debris samples from the areas of lowest burn, the points of origin in an accelerant fire where the flammable material pools before ignition, and submitted them to the Georgia Bureau of Investigation Crime Lab for chemical analysis. The lab returned results within 9 days, a turnaround that the lead investigator later described as faster than usual in his case notes. The results were positive for the presence of a petroleum distillate consistent with a common commercial-grade charcoal lighter fluid. The finding was consistent with the lab results from 2 of the 3 preceding fires. The investigators had their chemical link. The canvass that followed was similarly productive. Interviews with residents and business owners in a 6-block radius of the Flat Shoals property produced within 4 days a witness, a man who lived in an apartment building on the next block, who reported having seen an individual in the alley behind the burned property at approximately 10:30 p.m. on the night of the fire. The witness described the individual as a black male, approximately 5 feet 10, wearing a dark jacket and a baseball cap. He said the man had been carrying what appeared to be a plastic bag. He could not identify a face. He had not thought much of it at the time. The description was general. The investigators noted it and continued working outward from the scene, cross-referencing the witness canvases from the 3 preceding fires for any overlap in reported observations. On the 4th day of this cross-referencing, they identified what they described in the case file as a significant consistency. A resident near the site of the second fire, 6 weeks earlier, had reported seeing a man matching a broadly similar description, black male, dark clothing, baseball cap, in the vicinity of that property on the night it burned. The overlap was, the lead investigator wrote, notable. Jerome Antoine Washington had come to the investigators' attention through a separate channel. A tip had been received by the Atlanta Police Department's arson tip line, established following a public appeal after the third fire, 11 days before the Flat Shoals blaze. The tipster, who did not provide a name, stated that a man named Jerome, who lived near Flat Shoals Avenue, had been talking about fires in the neighborhood and had expressed what the tipster described as anger about the vacant properties in the area. The tip had been logged and forwarded to the Fire Investigation Unit. It had not, in the weeks between its receipt and the fourth fire, been acted upon. The unit's caseload was heavy. The tip was unspecific. These were the reasons the investigators gave in subsequent documentation for the delay. After the fourth fire, the tip acquired new significance. The investigators ran the name Jerome against address records in the Glenwood Park and East Side neighborhoods and identified Washington, a 37-year-old man who had lived on a street 1 block from the Flat Shoals property for 6 years. He had a prior arrest, not a conviction, for a misdemeanor property offense in 2014. He was unemployed at the time of the investigation and, according to the tip, had expressed opinions about vacant commercial properties in the neighborhood. The investigators interviewed Washington at his home 8 days after the Flat Shoals fire. The interview lasted 90 minutes. Washington denied any involvement in any of the 4 fires. He acknowledged knowing the Flat Shoals property. He acknowledged, when asked, that he had opinions about the blighted commercial properties in the neighborhood. He described them as eyesores that attracted crime and reduced property values. He acknowledged owning a dark jacket and a baseball cap. He acknowledged that he sometimes walked in the neighborhood at night. None of these acknowledgments constituted evidence of arson. Together, in the investigators' file, they constituted what the lead investigator's notes described as behavioral and circumstantial indicators consistent with subject involvement. A photo array was assembled and presented to the witness who had reported seeing a figure behind the Flat Shoals property. The array was administered by a detective not involved in the investigation. Washington's photograph was in position 4. The witness looked at the array for approximately 90 seconds and identified Washington as the individual he had seen in the alley. His confidence level, recorded on the standard form the department used for eyewitness identification documentation, was marked fairly certain. The investigators presented their findings to the Fulton County District Attorney's Office 22 days after the Flat Shoals fire. The presentation lasted 40 minutes. The assistant district attorney who received it asked 4 questions. She was satisfied with the answers. A warrant was issued. Washington was arrested. The Fire Investigation Unit closed the case series. Within the institution, the resolution of the 4 fire series was received as exactly what it appeared to be: professional work, competently executed, producing a timely result. The lead investigator was commended in writing by the unit commander. The cross-referencing methodology, the approach of overlaying witness canvases from multiple scenes to identify behavioral overlap, was cited as a model for future multi-incident investigations. The Atlanta Fire Rescue Department issued a brief statement noting that an arrest had been made in connection with a series of suspicious fires in the Glenwood Park and East Side neighborhoods. The statement described the investigation as having proceeded with efficiency and thoroughness. The efficiency was real. The thoroughness was a conclusion the institution had reached about itself before anyone outside it had examined the record. The case had moved from the fourth fire to an arrest in 22 days. Every step had been documented. Every finding had been reported. The machinery had performed without visible friction, and in the absence of friction, there had been no particular reason for anyone involved to slow down and ask what the speed itself might be obscuring. The case was closed. The system had done its work. In the conference rooms and incident logs of two separate agencies, Jerome Antoine Washington was the answer to a question that had been asked under pressure, in sequence, by professionals who were very good at their jobs and who had, without knowing it, already decided what the answer was. The Fire Investigation Unit's case file on the 4-fire series ran to 340 pages by the time it was submitted to the Fulton County District Attorney's Office. It was organized with the kind of institutional thoroughness that produces confidence in readers who are themselves operating under time pressure. Tabbed sections, chronological documentation, cross-referenced evidence logs, and a summary memorandum that presented the investigation's conclusions in clear, declarative language. The file looked complete because it had been assembled to look complete. What it recorded accurately was what the investigators had done. What it could not record, by definition, was what they had not done. The leads not pursued, the tests not ordered, the alternative theories considered briefly and set aside. Those absences left no pages in the file. They left no trace at all. The debris samples collected from the Flat Shoals scene had been submitted to the GBI crime lab for analysis of ignitable liquid residues. The lab's positive finding, petroleum distillate consistent with charcoal lighter fluid, was, as the investigators understood it, confirmation of the accelerant hypothesis. What they did not request, and what the lab therefore did not perform, was a more specific chemical characterization that might have distinguished between lighter fluid and other petroleum products with similar base compositions, including certain cleaning solvents, lubricants, and wood finishing compounds. The standard ignitable liquid residue test identifies the presence of a hydrocarbon class. It does not identify a specific product. The Flat Shoals property had been a dry cleaning business. The residual presence of petroleum-based cleaning compounds in the structural materials was a possibility that the more specific test, a full gas chromatography and mass spectrometry analysis, would have been designed to address. The investigators were aware of the more specific test. It was available through the same GBI lab that had processed the initial samples. The lead investigator's notes from the evidence submission stage include a single line: full GCMS if needed, hold pending initial results. The initial results came back positive. The need for further analysis was not revisited. This was not an unusual decision. Fire investigators routinely treat a positive ignitable liquid residue result as sufficient confirmation of the accelerant hypothesis and do not proceed to more specific characterization unless the initial result is negative or ambiguous. The protocol is defensible under standard fire investigation practice. It also meant that the most consequential piece of physical evidence in the case was examined to the depth required to confirm what the investigators already believed, and no further. The eyewitness identification produced by the photo array was the investigation's second foundational element, and it was treated with a confidence that the underlying circumstances did not fully support. The witness, the man who had observed a figure in the alley behind the Flat Shoals property, had provided his initial description 11 days before Washington's photograph was placed in an array for him to review. In the intervening 11 days, the Glenwood Park fires had been the subject of sustained local media coverage. The Atlanta Journal-Constitution had run 2 stories on the series. A local television news segment had aired a brief profile of the investigation, including a general description of the suspect the unit was seeking: a black male, adult, familiar with the neighborhood. The witness had not been asked, when the array was administered, whether he had followed the media coverage of the fires. The standard identification form used by the Atlanta Police Department at that time did not include a question about pre-identification media exposure. The form had not been updated since 2011. The sequential blind administration of the array, the procedure in which the administrator does not know which photograph depicts the suspect, was followed correctly in its technical requirements. The administrator was a detective from a separate unit who had not been briefed on the investigation. What the procedure did not control for was the witness's internal state at the time of the identification, what he had seen, read and heard in the days between his initial report and the moment he sat down with the photo array. The research on eyewitness memory is unambiguous on this point. Memory is not a recording. It is a reconstructive process, and reconstruction is sensitive to intervening information. An identification made after 11 days of media exposure to a general suspect description is not the same evidentiary object as an identification made in the immediate aftermath of an observed event, even when the procedural administration is technically correct. The Atlanta Police Department's identification protocol did not require investigators to document or account for this distinction. The protocol required that the administration be blind. It was blind. The form was complete. The identification was recorded as valid. The second witness, the resident near the earlier fire who had reported a broadly similar description, was not asked to view a photo array. The lead investigator's notes describe a decision made during the case synthesis stage, W2 description too general for reliable array, noted as corroborative only. This was a reasonable professional judgment. A description of a black male in dark clothing and a baseball cap is, in a neighborhood of several thousand residents, insufficiently specific to support a meaningful identification procedure. Submitting the second witness to an array under those circumstances risked producing a non-identification that would complicate the case without adding analytical value. The decision not to administer the array was made on those grounds. It was also a decision that removed the possibility of the second witness failing to identify Washington, an outcome that would have introduced doubt into a case file that was, at that point, building toward a consistent conclusion. The alternative suspects considered during the investigation received documentation in the case file that was thorough in form and limited in depth. 3 other individuals had been identified during the canvass process as persons with potential connections to one or more of the fire sites. One was a former tenant of the second fire property who had been involved in a lease dispute with the building's owner. One was a man known to frequent the alley behind the Flat Shoals property, described by multiple neighbors as regularly present in the area at night. One was an individual whose name appeared in 2 separate tip submissions to the arson line, though the tips themselves were vague and the submissions had been made by the same caller. Each of these individuals was documented in the case file under a section headed Additional Persons of Interest. Each entry included the individual's name, the basis for their inclusion, and a disposition note. The disposition notes read, respectively, eliminated, alibi provided and confirmed, eliminated, no connection to multiple sites established, and eliminated, duplicate tip, no corroborating information. The alibi confirmation for the first individual consisted of a single phone call to the person the individual had identified as his alibi witness. No independent verification of the alibi, phone records, surveillance footage, third-party confirmation had been sought. The confirmation was recorded as complete because the alibi witness had confirmed the alibi. The circularity of this process was not noted in the file. The man known to frequent the Flat Shoals alley had not been interviewed at all. The disposition note, no connection to multiple sites established, reflected the investigator's assessment that a person of interest needed to be connected to more than one fire site to merit continued attention, given their working hypothesis of a serial offender. This was a reasonable investigative framework, given the resources available and the timeline pressure the unit was operating under. It was also a framework that ensured the man most physically associated with the most recent fire scene would be eliminated from consideration without being asked to account for his presence. Viewed individually, none of these decisions would strike most experienced investigators as egregious. Stopping at the initial ignitable liquid residue result rather than proceeding to full GCMS analysis is standard practice in the majority of arson investigations. Relying on a technically correct identification procedure without accounting for pre-identification media exposure reflects a gap in the department's protocol, not a deviation from it. Eliminating alternative suspects based on single-source alibi confirmation is common in high-volume investigative environments where time and personnel are finite. Each decision was, within its own frame, reasonable. What the decisions share is a directionality. Each one moved the case forward. Each one reduced complexity. Each one made the existing theory easier to sustain rather than harder to prove. The file that arrived at the district attorney's office was the product of an investigation that had, at every decision point, chosen the path that led most efficiently toward the conclusion the investigators had already reached. The efficiency was genuine, so was the conclusion. What remained unclear, in ways the file was not designed to surface, was whether the conclusion had been reached because the evidence required it, or because the process had been organized incrementally and without conscious intent to produce it. The case felt resolved because the people who built it were good at making cases feel resolved. That competence and that limitation were, in the end, the same thing. The conviction of Jerome Antoine Washington on 2 counts of first-degree arson was returned by a Fulton County jury in November 2018, 9 months after his arrest. The trial lasted 6 days. The prosecution presented the ignitable liquid residue findings, the eyewitness identification, the behavioral evidence derived from the investigation, and the circumstantial pattern connecting Washington to the neighborhoods where the fires had occurred. The defense presented an alibi. Washington testified that he had been at home on the night of the Flat Shoals fire, and challenged the eyewitness identification through cross-examination that highlighted the darkness of the alley and the brevity of the witness's observation. The jury deliberated for 2 days before convicting on both counts. The judge sentenced Washington to 18 years. He was 41 years old at sentencing. He entered the Georgia Department of Corrections in January 2019. The case had moved from the 4th fire to a prison sentence in approximately 11 months. Within the institutions that had produced it, this was not a source of unease. It was a measure of performance. The ignitable liquid residue finding that anchored the physical evidence case against Washington was, by the time the trial concluded, the subject of a slow-moving professional reassessment that had not yet reached the operational level of most state and local fire investigation units, and would not, in most jurisdictions, for several more years. The science underlying ignitable liquid residue analysis had been under examination within the fire investigation and forensic chemistry communities since at least the early 2000s. The central concern was one that the GBI lab's standard testing protocol did not address: the phenomenon of pyrolysis. When organic materials burn, wood, carpet, synthetic flooring, insulation, the combustion process itself generates hydrocarbon compounds that can, under standard ignitable liquid residue analysis, produce results indistinguishable from those generated by the deliberate application of an accelerant. The dry cleaning business that had occupied the Flat Shoals property for more than 2 decades had used stored and likely spilled petroleum-based solvents in quantities that ordinary building materials would have absorbed over time. Those materials, subjected to the heat of a sustained structural fire, could generate the exact hydrocarbon signature that the GBI lab had identified in the debris samples. This was not a fringe finding. A 2011 report by the National Academy of Sciences titled "Strengthening Forensic Science in the United States" had specifically identified fire investigation as a discipline in which foundational scientific premises had not been adequately validated. A 2017 technical update published by the National Fire Protection Association, the organization whose guidelines govern fire investigation practice in most American jurisdictions, had incorporated language acknowledging the pyrolysis problem and recommending that investigators consider alternative explanations for ignitable liquid residue findings in structures with pre-existing hydrocarbon contamination. The GBI Crime Lab's standard protocol had not been updated to reflect either development. The testing method used to convict Washington was the same method that had been in use for more than a decade, applied to a type of property for which its reliability was, by 2018, a recognized open question in the professional literature. The lead investigator on the Washington case was not aware of the 2017 NFPA update. This is documented in a deposition he gave 3 years after the conviction, when a post-conviction legal challenge prompted discovery into the investigation's methodology. He testified that his training had not included the update and that the GBI lab's protocol was the standard he had been taught to rely upon. He was not dissembling. He was describing, with accuracy, the training environment he had operated in, one in which the professional literature's evolving understanding of a foundational forensic method had not filtered down to the practitioners who applied it daily. The gap between what the science had established and what the institution had incorporated into its operational practice was not a gap any individual had created. It was a gap that institutions create when they prioritize procedural continuity over methodological updating, and it is a gap that is found, in varying forms, across virtually every forensic discipline that the American criminal justice system deploys. The eyewitness identification, which had appeared at trial as the case's most direct evidentiary link between Washington and the Flat Shoals fire, was the subject of a separate and equally significant reliability problem. In 2020, a researcher at Georgia State University's law school, who was studying eyewitness identification practices in Fulton County, obtained, through a public records request, the identification documentation from a sample of arson cases prosecuted between 2015 and 2019. The Washington case was in the sample. The researcher's analysis noted several features of the identification process that the existing literature associated with elevated false identification risk. The 11-day interval between the initial observation and the array administration, the absence of any documentation regarding the witness's media exposure during that interval, and a feature of the identification form itself that had not been apparent from the case file's summary documentation. The standard Atlanta Police Department identification form in use at the time of Washington's arrest included an instruction to the witness that read in part, "Please look at the following photographs and tell me if you recognize anyone." The instruction did not include language recommended by the National Institute of Justice's 2017 Eyewitness Identification Guidelines. specifically the admonition that the person who committed the crime may or may not be present in the lineup. This language, which the research literature identifies as among the most effective interventions for reducing false identification rates, had been included in a draft revision to the Atlanta Police Department's identification protocol prepared in 2016. The revision had not been formally adopted. It was pending approval through the department's policy review process at the time of Washington's arrest, where it remained for another 18 months before being incorporated into operational practice in late 2019, a year after the identification that would send Washington to prison had already been made. The witness who identified Washington was not lying. The administrator who conducted the array had followed the protocol correctly. The prosecutor who introduced the identification at trial had no reason to question its validity. The procedure had been properly documented, the form had been correctly completed, and the identification had been made with a confidence level the form described as fairly certain. The evidence was legally adequate. It was also, by the standards the research community had established and the department had been in the process of adopting, produced by a method known to generate false identifications at rates that the legal system's admissibility standards do not account for. The institutional response to evidence of a case's fragility follows a pattern that is consistent enough across jurisdictions to be understood as structural rather than incidental. When the Georgia State Researchers' analysis was published in a law review article in 2021, it was reviewed by the Fulton County District Attorney's Conviction Review Unit, a division established in 2019 as part of a broader national movement toward prosecutorial accountability. The unit's review of the Washington case was initiated in early 2022. It proceeded over 14 months. The unit's final memorandum, issued in April 2023, concluded that the forensic evidence in the case presented questions of reliability that may warrant further examination, and that the identification procedure did not conform to subsequently adopted best practices. It stopped short of recommending a new trial. Its stated rationale was that the circumstantial evidence, the pattern connection, the behavioral indicators, the two broadly consistent witness descriptions, remained sufficient, independent of the forensic and identification evidence, to support the conviction. This conclusion illustrated a feature of post-conviction review that is as important as it is under-examined: the tendency of reviewing institutions to assess challenged evidence not in isolation, but in the context of the remaining case. The logic is intuitive. If multiple independent strands of evidence support a conviction, the unreliability of one strand does not necessarily undermine the whole. But this logic depends on the independence of those strands, on the premise that the challenged evidence and the remaining evidence were developed through separate processes from separate sources. In the Washington case, the two primary strands of evidence were not fully independent. The eyewitness identification had been developed after the investigators had identified Washington through the anonymous tip. The behavioral evidence had been assembled after the identification. The circumstantial pattern had been interpreted in light of all of the above. The case had been built sequentially, each element reinforcing the next, and the apparent independence of its components was partly an artifact of the way the file had been organized rather than a feature of how the evidence had actually been gathered. The Conviction Review Unit's assessment did not address this interdependence. It was not required to. Post-conviction review frameworks do not typically include methodological audits of investigative sequencing. They assess the legal sufficiency of the evidence that remains after challenged components are set aside. This is a narrower inquiry than the one the case required, and the narrowness was not accidental. It reflected the scope that the reviewing institution had established for itself, which was, in turn, a scope designed to be manageable rather than comprehensive. Jerome Antoine Washington had, by the time the Conviction Review Unit issued its memorandum, served 4 years of an 18-year sentence. The memorandum was not shared with his attorneys until 6 months after its issuance, following a records request. It did not constitute, under Georgia law, a basis for immediate relief. It was a document that acknowledged, in careful institutional language, that the case had problems, and then explained, in equally careful institutional language, why those problems did not require the institution to do anything about them. The case had been built on evidence that was legally adequate and scientifically uncertain. It had been maintained by a review process that was institutionally genuine and structurally limited. No one had fabricated the residue results. No one had coached the eyewitness. No one had designed the review process to fail. The system had produced a conviction through the accumulation of individually defensible steps, and it was now producing a defense of that conviction through the accumulation of individually defensible responses. The perfection of the original case had always been partly an appearance. What the post-conviction process revealed was that the institution had more investment in maintaining that appearance than in examining what lay behind it. Not because anyone had decided this, because the system, by its design, found it easier to defend a closed case than to reopen one. And closed cases, once defended, have a way of staying closed. The document that began to unravel the Washington case was not a confession, a recantation, or a dramatic revelation. It was a footnote. Specifically, it was footnote 47 in a 2022 peer-reviewed article published in the journal Fire Technology, co-authored by 2 forensic chemists at the University of Maryland and a fire investigation specialist from the Bureau of Alcohol, Tobacco, Firearms and Explosives. The article's subject was the reliability of standard ignitable liquid residue testing in structures with pre-existing hydrocarbon contamination. Footnote 47 cited, as an illustrative case study, a Georgia arson conviction from 2018 in which the primary physical evidence had been a positive ignitable liquid residue result from a former dry cleaning business. The case was not identified by name. The citation was to the GBI Crime Lab's internal protocol document, obtained through a Freedom of Information request by one of the article's co-authors during the research phase. A staff attorney at the Georgia Innocence Project read the article in the spring of 2022 as part of a literature review she was conducting for a different case. She recognized the case study's parameters. She pulled the Washington file, which the organization had received 18 months earlier, and placed on a review waitlist, and moved it to active status. The footnote had done what 4 years of Washington's pro-se post-conviction filings had not. It had placed the evidentiary problem in a register the institution was equipped to receive. Jerome Antoine Washington had filed 4 pro-se motions in the 4 years since his conviction. He had prepared them in the law library of the Autry State Prison in Pelham, Georgia, working from photocopied case law and a legal self-help manual published in 2009. The motions were not frivolous. They identified with varying degrees of precision the same problems that the peer-reviewed literature and the Georgia State researcher had subsequently documented: the reliability of the residue testing, the gap in the identification protocol, the unexamined alternative suspect. The courts that received the motions evaluated them against the standards that govern pro-se post-conviction petitions, standards that require, among other things, that claims be supported by specific factual allegations and that newly raised claims not have been available at the time of trial or direct appeal. The first motion was denied on procedural grounds. The claim had not been raised on direct appeal, and Washington had not demonstrated cause and prejudice for the default. The second was denied on the merits. The court found that the ignitable liquid residue evidence had been properly admitted under the standards governing scientific evidence in Georgia courts, and that Washington had not presented expert support sufficient to challenge the methodology. The third was transferred to a different court and denied without written opinion. The fourth, which had incorporated materials from the Georgia State Researchers Law Review article, was pending when the Innocence Project took the case. Each denial was legally correct within its own frame. Each applied the appropriate standard. Each produced a document, an order, an opinion, a docket notation that the system recorded as a resolution. The resolution was procedural. The underlying question the motions had raised, whether the physical evidence that had sent Washington to prison was reliable, remained unaddressed in any substantive sense. The system had answered the question of whether the motions met the legal standards for relief. It had not answered the question the motions were asking. The Innocence Project's investigation, conducted between the spring of 2022 and the fall of 2023, produced findings that reframed the case in ways the original investigation had not been designed to permit. A forensic chemist retained by the organization performed a retrospective analysis of the GBI lab's testing data from the Flat Shoals debris samples, the underlying chromatographic data that the lab had generated, but that the standard reporting protocol did not require to be included in the case file. The data had been preserved in the lab's archive. The forensic chemist's analysis identified hydrocarbon compounds in the sample consistent with the pyrolysis products of the specific synthetic flooring materials that the dry cleaning business had used, materials documented in the property's renovation permits from 2003, obtained from Fulton County records. The compounds were, in the chemist's professional opinion, more consistent with thermal decomposition of existing building materials than with the application of an external accelerant. The opinion did not exclude the possibility that an accelerant had been used. It established that the positive residue result was not, by itself, evidence that one had been. The organization's investigators also located, after an 8-month search, the man who had been identified in the original case file as having frequented the Flat Shoals alley. The individual the original investigation had eliminated without interview on the grounds that he could not be connected to multiple fire sites. The man, who had moved to Macon in 2019, agreed to speak with the investigators. He stated that he had been in the alley on the night of the Flat Shoals fire. He stated that he had been sleeping there, as he had done intermittently for several months, in a space between two dumpsters that was sheltered from the wind. He stated that he had seen a fire start near the building's rear entrance and had left when it began to spread. He stated that he had not reported what he saw because he was not supposed to be there and because he did not believe anyone would take his account seriously. His account was not, standing alone, exculpatory of Washington. It was the account of a man who had been present at the scene of a fire and who had not been asked at the time what he had seen. It was the account that a more complete investigation might have obtained in 2018, before the case was closed, before the indictment was filed, before the jury was seated. It was the kind of account that investigations conducted under time pressure and organized around a preferred conclusion do not always produce. Not because investigators suppress such accounts, but because they do not always go looking for them once they believe they have found something better. The motion for new trial filed by the Innocence Project in November 2023 was opposed by the Fulton County District Attorney's Office. The opposition was not reflexive. The Conviction Review Unit had been consulted. The new forensic analysis had been reviewed by a prosecution-retained expert who concluded that the Innocence Project's chemist had overstated the pyrolysis explanation and understated the significance of the original positive result. The two experts disagreed. This was, the prosecution argued, a battle of experts, not a demonstration of innocence, and the legal standard for a new trial based on newly discovered evidence required more than a competing expert opinion on a technical question. The legal standard the prosecution cited was accurate. Georgia courts have consistently held that newly discovered evidence must be of such a nature that it would probably produce a different verdict, not merely that it raises a question about the original evidence. The prosecution's argument was that the new forensic analysis, combined with the statement from the alley witness, raised questions. It did not, in the prosecution's assessment, meet the probability threshold. The trial court heard argument on the motion in February 2024. A ruling had not been issued at the time the materials for this account were last reviewed. Washington remained incarcerated. He had served 6 years of an 18-year sentence. The title of this account describes a case that closed too cleanly. That description was accurate when it was applied at the outset, and it acquires a different weight now. The speed of the original investigation was not in itself the source of the injustice that may have occurred. Fast investigations are not inherently unreliable, and slow ones are not inherently sound. What the speed reflected, and what the case's subsequent history has made visible, was the degree to which the investigation had been organized around the production of closure rather than the verification of truth. The 22 days between the fourth fire and Washington's arrest had been 22 days of building a case, not 22 days of testing a hypothesis. The distinction matters because it describes not an aberration, but a mode, a way that investigations proceed when institutional pressure, resource constraints, and professional incentives align around the goal of resolution. The Glenwood Park fires had alarmed a community and demanded a response. The Fire Investigation Unit had provided one. The District Attorney's Office had ratified it. The jury had accepted it. Each institution had done what its design equipped it to do, and what its design equipped it to do was, in each case, to process the case forward rather than to interrogate the assumptions on which it rested. Jerome Antoine Washington may be guilty. The evidence, in its current state of contest, does not establish his innocence. What it establishes is that the case against him was built on foundations that the system accepted without adequate examination and has since struggled to re-examine without conceding more than its institutional architecture permits. The case closed too cleanly because clean closures are what the system is calibrated to produce. Reopening them requires the system to work against its own design, which is to say against its own preferences, its own incentives, and its own settled understanding of what it accomplished when it closed the case in the first place. The question the case leaves open is not only whether Washington is innocent, it is whether a system that produces cases like his is capable of knowing the difference.